Megan Fox.
And Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox writes at PJ Media.
Eat Tucker.
Come out with your last. Damn it, man. I cried for 2 days.
Megan, thank you very much for that.
So, I can explain the bed thing.
If you don't show up and vote, up your ass. I don't care if you're in the hospital. Crawl to the stake. Crawl there.
It's like Jesus going to the temple. He's like, I got a whip. Get out! Get out! The lovely and wonderful Megan Fox. Not that one.
Not that one. Not the weird one that drinks blood in his toe thumb.
Megan Fox.
Megan. And honestly, Megan, if you don't like it, I'm sorry.
She's the devil. Megan.
Megan Fox. Megan Fox.
I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
You've never met a like me. You want to tangle? You want to go?
Holy sh**.
Too much cussing on this. I guess we didn't bleep it, so we got to turn it off. But it's
You pissed off the wrong woman.
oh my God, I have been assaulted when Megan Fox runs wild on you, brother.
She's the devil.
Not for publication.
The story.
I'm Megan Fox. Thank you. Cheers.
Well, hello there. Whatever time it is, good morning, good afternoon, good evening. It's me, it's the Megan Fox program. Welcome back to my channel. Happy to have you here. There is a lot going on. Every story always has to blow up at the same time. Every story. So what should we start with? I think we should start with Gregg Woodnick and his filing, his most recent filing, because that's what you're probably here for. I forgot to send this out on Twitter. There we go. How's it going? I should start with hair care. I don't know. I haven't given much care to my hair since Florida, although I've noticed I cannot straighten it. If I straighten it, it is dry as hell. So all I'm doing right now is just putting massive amounts of conditioner in it, because between the pools and the sun in Florida, it has just, especially on this top layer of hair, it has done damage. So I'm just like squeezing conditioner in and letting it dry. I'm not even using a hair dryer right now. I'm just letting it air dry because I'm afraid of the heat damage. Channel 20. Yes. You emailed me the Channel 20 link. Thank you very much. I was just wondering where that was, because I closed windows I shouldn't have closed, and I had stuff open and I lost that one in particular. But yeah, that one's really the What the Hales update that's coming up, it's really going to annoy you. Why did they interview Lynette Preston who wasn't there? The only witness that they interviewed was someone who wasn't there. Is that a joke? That has to be a joke. Did I start early? No, I started on time. At exactly 11:45. I pushed the go live button. Are you proud of me? MG, if you want to get in here, you're invited. I wanted to be on with you last night, but I couldn't do it. My throat was completely shot after 3.5 hours on Tug's stream. I couldn't do it. I started coughing. I will send you a link if you want to join me. On Twitter. There you go. Okay. All right, let's pull up Gregg Woodnick's most recent filing, shall we? It's very short and to the point. Let's see. Unlike David Gingras' filings, the man has never done anything short and to the point, except for possibly his love life. I'm not sure. I don't know how that... Allegedly. Response to notice of change of judge for cause. Pursuant to Rule 6.1d, Respondent Clayton Echard hereby responds to Petitioner Laura Owens' notice of change of judge for cause, filed July 8th, 2024, and requests the court deny the notice as untimely. Yeah, those time limits are a real thing. You got to pay attention. Respondent also objects to the salacious allegations contained in petitioner's filings, gross misrepresentations, reckless incendiary comments impugning the integrity of Judge Mata. Footnote number 1, counsel comments that Judge Mata was trying to impress her father. Look at me, Daddy. I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. Hee hee. I can't really even expound on that. It's so bad. It's so bad. And by the way, it's so bad that the lawyers I know on Twitter, like Ian Runkle and Lon Lumber, were like, holy shit, is that real? And Ian asked me for the filing, so I'm pretty sure that he's going to be covering it. I can't wait until he does. But every single lawyer that has seen this has gone, oh, no, stop. And insufficient grounds to find bias on the merits. But the court need not reach the sufficiency of the grounds because the notice is irredeemably time-barred and inappropriately invoked. Neither ARS 12409 nor its implementation via Rule 6.1 permit change of judge by affidavit of bias and prejudice after final trial. Let's see. Actually, let me look up. I want to see what that rule is we're citing. ARS 12409. Change of judge grounds. Okay, let's look at this. Let's just read it, shall we? That's a good idea. Let's look at the law that he was citing to see if it's in there. Change of judge grounds. If either party to a civil action in a superior court files an affidavit alleging any of the grounds specified in subsection B, the judge shall at once transfer the action to another division of the court if there is more than one division, or shall request a judge of the superior court of another county to preside at the trial of action, but only if these things are met. B. Grounds which may be alleged as provided in subsection A for change of judge are 1. That the judge has been engaged as counsel in the action prior to the appointment or election as judge. Well, that's not it. You can check that one off the list. 2. The judge is otherwise interested in the action. No. 3. That the judge is of kin or related to either party to the action. No. 4. That the judge is a material witness in the action. Definitely not. 5. that the party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. That's the one that he's claiming that he has. But of course, he hasn't given any evidence of that at all. All right, what was the other thing? Rule 6.1. So let's look at Rule 6.1. Hang on a second. Where did it go? There we go. Rule 6.1, Arizona, Rules of Criminal Procedure. Right to counsel and change of judge for cause. All right, let's pull this up. There. There we go. Right to be represented, right to an attorney, right to counsel. Yeah. Wait, where's the change of judge? Right to be appointed an attorney. I don't see the change of judge in here. Paraprofessional. Indigency. It's not there. Am I missing something? Oh, Family Rule 6.1. Gotcha. All right, let's try that again. Family Law Rule 6.1, Arizona. Here we go. Okay. A party seeking a change of judge for cause must establish grounds by affidavit as required by the law. Filing and service affidavit must be filed and copies served on the parties, the presiding judge, and the notice judge, and the court administrator, if any, by any method provided in Rule 43B. Timelines. This is probably important. A party must file an affidavit seeking a change of judge for cause within 20 days after discovering that grounds exist for a change of judge. Case events or actions taken before that discovery do not waive a party's right to a change of judge for cause. Okay. Hearing and assignment. If a party timely files and serves an affidavit complying with the law, within 5 days after the affidavit is served, any other party may file an opposing affidavit or a response of no more than 2 pages. No reply or affidavits are permitted unless authorized by presiding judge. The presiding judge may hold a hearing to determine the issues raised in the affidavit or may decide the issues based on any affidavits and memoranda filed by the parties. On filing of the affidavit for cause, the named judge should proceed no further in the action except to make such temporary orders as are necessary to prevent immediate and irreparable harm from occurring before the request is decided and the action transferred. However, if the named judge is the only judge in the county, that judge may also perform the functions of the presiding judge. The presiding judge must decide the issues by the preponderance of the evidence. Under ARS 12409, the sufficiency of any cause to believe must be determined by an objective standard, not by reference to the affiant's subjective belief. If grounds for disqualification are found, the presiding judge must promptly reassign the action. If the court determines that the party who filed the affidavit is not entitled to a change of judge, the named judge may proceed with the action. All right, so 20 days, it says, you know what it doesn't say here, though? It says within 20 days after discovering the grounds exist, but I don't think that he can file it after the trial is completed. But we'll see. We shall see. All right, let's go back to Woodnick's filing and see what his argument will be. which I'm sure is a lot more merit than David Gingras's. All right. He says neither 12409 nor its implementation of Rule 6.1 permit change of judge by affidavit of bias and prejudice after final trial. History of common law preemptory challenge. Oh my God, we're going all the way back to common law. Isn't that like 14 something, 15 something? Arizona long acknowledged a right to change judges upon filing an affidavit of reasonable belief of bias or prejudice. See Stevens v. Stevens, Arizona 1915, Allen v. Allen 1919. Early territorial statutes codified this right, and it was later implemented by procedural rules. Footnote number 2. Civil Code 1913, 500 can be traced with functionally identical language through to ARS 12409 via the 1955 reorganization of laws into the Arizona Revised Statutes. See Brush-Wellman, Inc. v. Lee. Although the Supreme Court has refined the procedures, the right itself is not sourced from the procedural rules. Time limit for challenge via affidavit of bias and prejudice. The relevant language of the law as it exists today is functionally identical to the 1913 Civil Code provision, which itself gave form to its common law antecedent and an 1887 Territorial Code provision. The court must reassign the action to another judge to preside at the trial of the action upon a party filing an affidavit showing cause to believe the actual belief that she cannot obtain a fair and impartial trial on account of bias of the judge. See Stevens at 309, Hordick v. Farley. The language of the statute in 1915 was in all essentials identical to the language of the statute today. The Hordick decision reiterates that change of judge upon a timely filed affidavit works automatically. Hordick at 193. As to filing the affidavit in time, Hordick approves and expands on Stevens and Allen, both of which endorse strict limits to filing before final trial. Stevens held that filing 1 day before trial did not waive the right, but Allen held that a party filing the affidavit after trial had already commenced did not act with diligence sufficient to require the trial court to take cognizance of her application. The party is not permitted to wait until he sees which way the decision is going to go before deciding whether to stay with or try to eliminate the judge who is hearing the matter. Boom. Because that's exactly what happens. That's exactly what happened here. Nor is he permitted to wait until the judge has heard evidence on the merits, which will have to be resubmitted if another judge is substituted. West v. Superior Court, 104, Arizona, 1968, emphasis added. Wow. Petitioner's reading of Del Castillo v. Wells is not supported. Of course not. So basically, the petitioner misread this law that he quoted, the case law that he quoted. Where have we seen this before? Procedural rules implementing ARS 12409, like ARCP 42, did not create a separate and distinct remedy from the statute. It simply modified the procedures to be followed. Brush-Wellman, Inc., v. Lee, Del Castillo expressly rejects the notion that procedural rules implementing the law create separate and distinct remedies. Del Castillo, cited here, 1974. In fact, Rule 6.1 increases the burden by requiring the affiant to prove the sufficiency of cause to believe bias by an objective standard, i.e., the affidavit itself must have substantive merit. You mean it can't rely on third-hand hearsay? Really? It can't rely on, well, I heard that so-and-so was sitting next to a guy who claimed to be the judge's dad. You mean that's not substantive? Color me shocked. It does not expand statutory rights or create new ones. The court must simply reject the notice as time-barred because it was filed after final trial and final judgment under Rule 78. Oh, what's Rule 78? Hold, please. I'd like to say good morning or good afternoon to the Locals chat as well, meganfox.locals.com, and to the Rumble Ghetto. I see you over there. There aren't many of you, but there are some of you. So good morning, Rumble. Good afternoon, Rumble. Good evening, Rumble, wherever you are. Rule 78. Let's see. All right. Let's pull it up. How do I pull this up? Rule 78 language. No, I want to see the actual rule. I don't want to read your... Here it is. All right. Let's see if there's anything in here that we can ascertain as relevant. Definitions. Form. Judgment, as used in these rules, as a decree of dissolution of marriage, a decree of legal separation, a decree of dissolution of a covenant marriage, a decree of legal separation of annulment, judgments of paternity and maternity. So there we are. And a decision defining or modifying legal decision-making, blah, blah, blah. A temporary order is not a judgment. A decision resolving any petition listed in Rule 23A or any post-judgment petition filed under Rule 91 is a judgment. Decision, as used in this rule, is a written order, ruling, or minute entry that adjudicates at least one claim or defense. Judgment upon multiple claims or involving multiple parties. When more than one claim for relief is presented in an action, whether as a claim, counterclaim, or third-party claim, or petition to modify or enforce a judgment, the court may direct the entry of an appealable judgment as to one or more but fewer than all claims or parties only if the court expressly determines that there is no just reason for delay and recites that the judgment is entered under Rule 78B. All right, so I think this is regarding the final judgment. So a final judgment was entered, and that was Judge Mata's ruling, and it is final. So I think what this is basically saying is if you have a problem with it, you need to take it to the appeals court. You don't get to just bitch about a final judgment to a lateral judge. Like, you can't do that. If there is no such express determination in recital, any decision, however designated, that adjudicates fewer than all the claims or the rights or liabilities of fewer than all the parties does not end the action as to any claims or parties, but that's not what we're dealing with here, and is subject to revision at any time before the entry of a judgment adjudicating all the claims. Right. So if there wasn't a final judgment, then it would be subject to revision, but that's not what happened here. Judgment as to all claims is not, here we go, a judgment as to all claims, issues, and parties is not appealable unless the judgment recites that no further matters remain pending and that the judgment is entered under Rule 78C. Well, there's still a matter pending here, isn't there? There's attorney's fees. So is it even appealable at this point? MG, do you know? Yeah, a judge made those determinations in her ruling. Yeah. Yeah, I'm being quiet because my throat, my voice is still not back. Asserting a claim for attorney's fees, costs, and expenses must be made in the pleadings or by motion filed before trial or a post-judgment evidentiary hearing. Yep, that was done. Time of determination. Objections to form of judgment. Proposed forms of judgment must be served on all parties. Objections to form. A judgment may not be entered until 5 days after the proposed form of judgment is served, unless blah, blah, blah. Opposing party not in default may file an objection, to the proposed form of judgment within 5 days. Entering judgment, a written document. We have that. Written and signed by the judge. Yep. Time and matter of entry. Latin. Nunc pro tunc. Latin is so weird. A judgment, including a judgment in the form of a minute entry. Yep, it was filed. Notice of entry of judgment. All right. Lack of notice to the entry of judgment by the clerk does not affect the time to appeal. All right, I'm not seeing anything in here that necessarily stands out at me. But it sounds to me like everything was done correctly. All right, let's go back over to the ruling. Not the ruling, the motion. Nope, Megan, that's the wrong button. Here we go. All right, the court must simply reject the notice as time-barred because it was filed after final trial and final judgment under Rule 78. And I think basically what we saw under Rule 78 is just that once it's filed properly, the final judgment, that's it. You have to put on your big boy pants and go up to the appellate court then. You don't get to just, complain and whine and mock the judge. By the way, those of you who are on Twitter maybe want to make sure that you're still tagging the county attorney and encouraging her and thanking her for paying attention to false accusations. And, be nice and encouraging to the county attorney, Rachel Mitchell, because she is looking into it. She has assigned a investigator, but we don't want her to forget that we're still out here hoping for justice. And, I think if they investigate this, they're going to find a whole lot more things they can charge her with. And also the bar, the Arizona State Bar, keep tagging them in this crazy stuff that Gingras keeps doing. And, be nice to them too. We know that that most of the time the bar is really, I don't want to say lax, but they hesitate to do anything about attorneys who aren't stealing from their clients. That's really the only thing that gets your license yanked is money crimes. Pretty much everything else they ignore. So keep on, alerting them to this kind of behavior, because I've never seen as sanctionable behavior as what we've seen in that last motion that he wrote, going after the judge like that. Holy crap. He better hope that the presiding judge that he sent that to is as nice as Judge Mata, because if she isn't, he may be in trouble from her. Who knows? I can't wait to hear what she has to say. All right. So wherefore, respondent requests the following: an order rejecting the notice of change of judge. Yeah, they're looking for this.
Denied. Sit down.
An order granting leave for respondent to file a supplemental affidavit of attorney's fees and costs. So, in other words, you made us sit down and write this, and now you need to pay for that too. So now we're going to up our what you owe us on this. which is hilarious. And 3, entering any further orders necessary and appropriate, considering Rule 8.2 of the Arizona Rules of Professional Conduct. So, in other words, it is a little nudge to the judge that, hey, you might want to slap this guy based on Rule 8.2a of the Arizona Rules of Professional Conduct. Let's look up what that is, shall we? Rule 8.2a. 8.2a, Rules of Professional Conduct. A lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or the integrity of a judge or another adjudicatory officer or of a candidate for election or appointment to the judicial office. Well. I would say that this is a really good motion. It's straight and to the point. It has nothing frivolous or fluffy in it like David Gingras. There's no padding. There's no nothing. It's just, here's why he's wrong. Here's why he's wrong. And you should slap him with sanctions for it. Because he's also a dick. That's basically what this motion says. He's wrong. Here's why he's wrong. And this guy's a dick and he needs to be sanctioned. So that's my summary of
Denied. Sit down.
I hope that the presiding judge has this going through her mind when she's reading that motion.
You will pay for what you've done. And I pray that God send angels to visit vengeance upon you.
My Lord. All right. So that's done. All right. Let's look at what is going on with Laura Owens on Twitter, because this is disturbing. So I believe somebody has paid for some, and I said Chinese, but it's Korean. My daughter who loves K-pop would be so disappointed in me that I didn't recognize Korean writing, but what are you going to do? I don't know. But let's see. Check this out. This is what happens when you go search Laura Owens without the hashtag now on Twitter. Let me pull this up. I took this little video. Check this out. Before you can get to any of our tweets about this, this is what you have to go through. And these all say they're from Laura Owens. Do you see this? Look at all these. I know it's scrolling kind of fast, but this is hiding your tweets about Laura Owens. Look at all these bots, you guys. And it's just these random, like, and then finally, after all that, you'll get down to the tweets about her. Yeah. Somebody's doing this. Now, who would want to do this? I wonder, who might it be? So, my suggestion to you is if you want to overcome the bot activity, and she's kind of half-assing it, by the way. It's not a whole bunch of them. I don't know how much, this cost, probably not very much because it's not, thousands or anything, but they are the top results. So what I suggest is when you're tweeting about this case, that you now use her name without the hashtag and also with the hashtag, so that when you have just Laura space Owens, that those start populating at the top as well. So that's how you can help out to overcome bot activity. Yeah, but I mean, okay, Sammy says it wouldn't be so sus if it wasn't all the same picture. Do you believe that there's someone in Korea with the name Laura Owens? No. It's so very clearly, a hack job. New video to investigate urgently. Minnesota Black Robe. A state trooper did what? Police officer drinking on job, showing off to unofficial ride along, kills an 18-year-old? Oh my God. What? All right, let me star that for later. All right, let's get to some of your super chats here. Unhung Hero says, watch Gingras get in trouble with the bar after all of his bloviating about getting others in trouble. That would be hilarious. I would like that very much. Liaison Aeon, thanks for the 2. Can you find the lie in her statement to the news? Oh yeah, we're going to get to that. We're going to get to Lynette and her statement to the news. Fake Laura Owens, thanks for the 5. Gingras, untimely filings sort of might be my fault. I only let him out of the GIMP suit a few hours a week now. Sarah Adams, thanks for the 2. This is hashtag sore loser and all its tears. Grandma Ray Ray, thanks for the 2. Rule 6.0D says prior to trial. Oh, let me see. Rule 6.0D, Arizona. Time limits. A party is precluded from obtaining a change of judge as a matter of right unless the party files a timely notice. The notice must be filed 60 or more days before a scheduled contested hearing or trial. There it is. Oh, good find. There it is. Here, let's present this. Did he just miss this? It's right there. It's literally right there. The notice must be filed 60 or more days before a scheduled contested hearing or trial. What? You lose.
Denied. Sit down.
The trial's over. Thank you for that, Grandma Ray Ray. BS, thanks for the 10. Yay, good morning. Keep up the great reporting. Would rather give you my money than ABC and NBC, CNN, or any other network. This is so much better. Happy Friday. Well, thank you. And that's why YouTube is so great because, we're not beholden to any advertisers. We're not beholden to big corporations. And so, nobody tells me what to say. I just say what I think. I say and I show you what I find and, you guys can decide whether or not you want to support it, and I sure appreciate those of you who do. Sarah Adams, thanks for the 2. Should we tweet at her in Chinese as well? And or Korean. Let's be inclusive. Okay, let's get to the what the Hales thing, because I think... Oh, no, wait. We have one more thing on the Laura Owens updates. What was it? Brad, you reminded me of it a few minutes ago, and I've already forgotten. I can't find my pills since my trip, which is bad news. They're buried somewhere in a bag that I haven't unpacked yet. If you guys were wondering what Lego project that I was working on last night, it was this little dolphin, which is the 3rd iteration of my... First, it was the guitar. Remember the turquoise guitar? And then the surfboard, which I've had up here for a while. And now I did the little dolphin, and it has... Look how cute this little clamshell with the oyster with the pearl inside and the little palm tree that can move. Check it out. I mean, how cute is this? Oh yeah, Dave Neal bar complaint. Thank you, Brad. Yeah, this is what I was doing last night. So I've made all 3 of that 3-in-1 and all 3 of this 3-in-1. So now I just have to start over again. And I've done all 3 of the Main Street one as well. And I rebuilt the original. I'm working on that. I have like one more floor of the hotel to go. No, I didn't lose the turtle. I have the turtle. It's still in my bag though. I did lose the dolphin, though. Don't tell the expert. Shh. I don't know where that went. All right, Dave Neal's bar complaint. So, Dave put a bar complaint into... He complained about the... Let's see if I can pull this up. He complained to the bar about the threats from David Gingras. And that was a while ago. And I guess they finally just responded. A lot of you don't believe this is a real response. I do. I do believe it's real. Hold on, let me get this back. I believe it's real, but a bunch of you don't. But it's not signed all the best or anything. So let's see. Good afternoon, Mr. Gingras. Now this is dated May 10th. This email will serve to confirm that this bar charge matter involving Mr. Dave Neal is being dismissed and closed. Moving forward, please be mindful of and keep in mind our conversation about professionalism and the comments that you are making about other individuals in your social media and on the blogs in your website. Please refrain from personally insulting language and name-calling directed at other individuals. Your professionalism obligations would be better suited, as well as your service to your clients and the legal community at large. That is not a complete sentence. Your professional obligations would be better suited to what? That's a fragment. Better suited if you did this other thing instead of the thing you're doing. But this is a fragment. That bothers me. Your professionalism obligations would be better suited, as well as your service to your clients and the legal community at large. That's a fragment. Again, I very much appreciated our conversation on the matter. Thank you for the time and attention that you provided to me and to this matter. Please also extend my thanks to Ms. Owens for her time and attention. It all is greatly appreciated. Why in the world would the bar talk to Laura about the behavior of her attorney? And you know, all she was going to say was, wait, hold on. Where's my voice?
I'm being cyberbullied by this guy named Dave Neal. Him and his friends called me a dumbass. And my lawyer was just responding to it on my behalf. He was standing up for me.
Like what? Why would that be at all helpful to the bar? It's so strange. I mean, I agree that this letter is weird, but that's not the only bar complaint that's out there. To my knowledge, there are a few more. So I guess we will find out what happens and if the Arizona State Bar is serious about about upholding their ethical standards. I think the worst thing that he's done, though, is admit that he thinks his client has an underlying mental health condition, which would mean that she was of diminished capacity. And yet he allowed her to embarrass herself on his Twitter feed by posting that weird video of her in the belly and lifting up her shirt and her bra and everything out there for the world to see and her thong hanging out. Like, why would you do that to your client? Like, I couldn't even watch that video. I had so much secondhand embarrassment for that video. I don't think I played it on this channel. I was just like, ew, no. I mean, and all the other things he let her do. Writing the unaliving threat on his blog. E. Poindexter, thanks for the 20. Timing is everything. Happy Breadstick Friday. Breadstick money. We got to play that soon. Wizzy Wheels, thanks for the 2. That's keeping me company while I'm in the hospital. Or thanks for keeping me company while I'm in the hospital. I'm sorry you're in the hospital. Hope you get better soon. Fake Laura Owens, thanks for the 5. bar complaint? I don't even know what that is. I thought a bar is where I pick up my next victim. I mean, meet guys. So good. I know you guys think this letter is suspect. All right, let's put up a poll. Where's my YouTube studio? Where's the studio? Ah, here it is. All right, let's put up a poll. Who thinks this is real or who thinks it's fake? But I think it's real. All right. The letter from the bar, from the Arizona bar, is sadly real. Fake AF. All right, there you go. There you go. What's winning so far? 50-50. It's 50-50. Oh, nope, 60-40. What, 61, 64? We're moving up. Fake is winning by a little bit. Fakety fake, fake, fake. Well, I don't know if it's suspicious that they spoke to Laura. I mean, I just don't know why they would need to. This is about a lawyer and his behavior. And the bar is very familiar with her. Aren't they? I mean, she's written that Arizona State Bar a bazillion times. And they've denied all of her requests previously. Like, they know what a problem she is. So why on earth would they take anything she had to say with anything more than total skepticism? That's a weird thing. Like, I think this letter's real, but I think it's weird that they would give her testimony any credibility whatsoever. Well, why would you do that? Why would you? You know that she's been adjudicated a liar. You know this.
She lied.
What?
This is the face I make when I hear this.
What?
What? I don't think that her attorney would put out an altered letter, though. Oh, he tweeted? Okay, all right, let's look at his tweet. He's been locking up his tweets, by the way, so no one can respond. And I thought he was the free speech lawyer. Although, I mean, I respect his right to not have people trolling him. You know, I do that. I believe in free speech, but I don't let people troll me. But still, for him, it's a little strange because he's like, you know, all right, here we go. I knew he was going to do this. I told you this yesterday. All right, let's share this. No, not that. Where is it? There. Damn. Why does it keep moving? There. All right. Shoot. No, go back. Submitted to the court this morning in reply to Woodnick's response to notice of change of judge. Later this morning, we'll also be filing a substantive motion to see. Well, I hope it's substantive because so far you've given us absolutely nothing of substance. Seeking a new trial and other relief, which I'll post when done. This is David Gingras to Maribeth Burrows. I don't know who that is. Miss Wallach. Family Law Rule 6.1D1 provides that responses opposing a change of judge may be no more than 2 pages, and no reply is permitted unless authorized by the presiding judge. Since Mr. Woodnick submitted a 4-page response without leave of court, we would respectfully ask Judge Fisk to permit the following 2 short points in reply. Well, you know you're supposed to respond in a motion and not an email, Dingus. Haven't you learned this yet? First, Mr. Woodnick does not dispute the factual basis for our request. He does not challenge or even mention our evidence showing that Judge Mata performed an independent... There's no evidence she performed an independent investigation into the facts. And by the way, Gregg Woodnick, it's not his responsibility to respond to that ridiculous claim because he isn't the one being alleged to have done anything wrong. He doesn't speak on behalf of Judge Mata. That is for the judge to decide. And Gregg's got what would Gregg say? What is he supposed to say? I didn't see anything. I mean, what knowledge would he have? Yeah, MG says, so he's trying to get it stricken, but he's going to send an ex parte communication to the court first. Well, I mean, he did copy Gregg and Isabel, and Marcus, but this is so stupid. This is so stupid. He keeps doing this, and he keeps getting slapped down.
Denied. Sit down.
Why does he do this?
This will get awkward.
It's so awkward watching this man work. All right, let's keep reading this. And by the way, I don't think that Gregg's response was 4 pages because that first page is taken up by all of that, the header. I bet it's like 3. Does not dispute the factual... He didn't have any factual basis for the request. And that she included findings in her judgment which were copied from social media. Because you didn't show that she did that. For all we know, she had personal knowledge of when Planned Parenthood was open or not open. For God's sake. Because Family Law Rule 6.1D3 requires grounds for disqualification to be proven by a preponderance of evidence, and because Mr. Woodnick does not dispute the grounds raised in our notice, Judge Fisk should find the grounds for disqualification are established. I don't think that he has the purview. I don't think Gregg has the purview to argue his stupid grounds because they involve the judge and not Woodnick's client. Gregg Woodnick is not the attorney for Judge Mata. He can't defend her. Am I reading that wrong, MG? Am I getting the right idea here? This is stupid. Second, the only argument Mr. Woodnick presents is that our notice is untimely. Well, if it's untimely, guess what? Nothing else matters. You're fucked.
Denied. Sit down.
Oh my God. However, this argument is based on the wrong rule. Mr. Woodnick is referring to the standards for a change of judge as a matter of right under Rule 6 and not a change of judge for cause under Rule 6.1. Rule 6, allowing a change of judge as a right, is extremely clear that a party waives their right to change of judge if the judge rules on any contested issue. Rule 6E2. Here, if we had invoked Rule 6, I would agree with Mr. Woodnick 100%. The request would be untimely because Judge Mata has already ruled on numerous contested issues. But we have not invoked Rule 6. Rather, we have sought a change of judge for cause under a different rule, 6.1. The standards under Rule 6.1 are entirely different. Rule 6.1c merely requires that the notice be filed within 20 days of discovering the grounds for the notice, and the rule expressly states, case events or actions taken before that discovery do not waive a party's right to change of judge for cause. Well, I think, though, that the final judgment is not considered case events or actions. That's just like, it's over, man. I don't know. I could be wrong, but it's over. I mean, he has the right to go to the appellate court, but he's trying desperately to stay out of the appellate court for some reason. Why is he doing that? Just appeal, dude. Appeal. Because appeals are for losers, which is where you belong, in the appellate court. Mr. Woodnick does not dispute that our notice was timely under Rule 6.1c, and he has not challenged the factual basis for the notice. I don't know. It felt like he did to me. I think he does dispute it. Accordingly, Mr. Woodnick's objection is frivolous. Oh my God.
What?
This guy, is saying that somebody else's motion is frivolous. That's the funniest thing I've ever heard. Oh my God. Mr. Motion to compel lunch? I'm... Come on. Motion to compel lunch man says this is frivolous. The very dry, law-centered, short response to his 200-page motion, his frivolous motion that included, "Look at me, Daddy, I'm a real judge now." Holy crap. And our notice should be granted. And why is he doing this in an email? He's going to get the same response, which is, dude, put it in a motion. The hell is wrong with you? Why are you like this? Oh my God. Did he? Oh, he left open his replies. Shall we see what they say? No. I don't want to reply. I want to see the replies. What, did he hide them? It says he has 4 replies, but I can't see any of them. Why is that? Is he hiding replies? This guy. Does he have any new replies? "16 hours ago. Oh God, this guy. This guy. All right. I'm done with him. He's so boring. Oh, look who the cat dragged in.
Well, hello.
Well, hello there.
You were looking for the replies. I have the replies.
Oh, yeah? Oh, the ones that he hid?
They're not hidden.
Why can't I see them?
I don't know.
Well, they're not there for me.
Looks like he blocked Fenchurch because it was... I've got it up on one screen and... God dang it. Go over here. Yeah. So Fenchurch said, "I assume you'll be appealing as well as making for a new trial. Which avenue do you think would be a better result or would be result in a better outcome for Laura Owens?" Fenchurch, I'm disappointed at your grammar. "An appellate ruling or a new trial if either were to happen." Not going to work. It's over. Put a fork in it. You're giving me the creeps. Crackhead thinks everyone but him is wrong. Go figure. He's not a crackhead. He's just weird.
Actually, I wouldn't be too sure about that.
Well, I do not make such accusations.
I'm not making the accusation. I'm saying I just wouldn't be. I'm not sure whether he's on illicit substances or not. I'm starting to think it's more likely than not. I think he needs to be, sent for a urine test, possibly a hair test.
But the weird thing is that we already know he has a deadline for replying to Gregg's motion for application of attorney's fees. And that response is a week from yesterday. So, in addition to filing his notice of appeal. So, I don't know why he's wasting his time with this when he can go for the appeal. Now, I imagine the only reason that he's going to not want the appeal is that they're going to have to bond out the attorney's fees if they get everything that's asked for. And she would have to come up with approximately $150,000 to be able to support the appeal.
Mm-hmm.
And if she bonds it, then it could go straight to Woodnick as soon as the appeal is denied. And then Woodnick is very happy that he has all of the money for all of the work that they've invested in this. But if they can try and get a new trial without having to pay attorney's fees, then they don't have to come up with that money, and they can continue to try and bleed them of resources until they hopefully get the outcome they want.
Ridiculous. I don't think he's got anything appealable. And even if the only appealable issue he has hit on that he might have is if he can prove that the judge did some kind of outside thing, but then he would have to prove that it was not just a harmless error, right? That it was a structural error. And let's say that happened, all he gets is a new trial, and he's got the same set of shitty facts. I don't know who would want to dedicate their lives to this.
In addition to more perjury to point out.
Yeah, more perjury. This is why we have to keep on encouraging the county attorney to press charges.
Did you see that list that someone created of all of the...
Yes. Oh my God. We should go over that.
You got to pull that up because that's...
Yeah.
If we're keeping score, that's the name.
Yeah. On Reddit.
There. It's in the private chat.
Oh, you're so much faster than me. Which, of course, is why I have you here. Here we go. Let's see. Share screen. Yeah, this is great. So, therefore, by grace go I on Reddit has made this incredible list. Let's go over it. If we're keeping score. So after reading all the motions, Judge Mata found it uncredible and unreasonable that JD claimed pregnancy 11 days after fellatio, took multiple HCG tests but never attended a confirmatory appointment, attended an appointment at an urgent care for an urine test, denied having a sonogram and then reversed her claim, alleged she took a gazillion more P-stick tests after her PP sonogram on July 7th or July 2, or was it June 28th, June 22nd, changed her testimony regarding the date of her sonogram multiple times, changed her testimony regarding the location of her sonogram, including on the date of trial, altered the sonogram data, sent fabricated and or stolen sonograms to Clayton and journalists, denied sending fabricated and or stolen sonograms to Clayton and journalists, accused a previous one-night stand of hacking her email and sending to Clayton and journalists the images she fabricated and or stole, did not seek reasonable follow-up care as directed after passing 2 alleged sacks on July 17th, 23rd, 28th, immediately resumed horse jumping, harassed the alleged father to the point of an order of harassment, made an extortion coercion attempt to date her in exchange for an abortion, filed a parenting plan with the court after allegedly passing fetal sacs and trying to coerce the abortion, abused the court system, public resources, and even the FBI to further her harassment campaign, stalked female associates of Clayton in Florida, contacted employers to defame Clayton, tortious contractual interference, contacted many local, national, and international news outlets to defame Clayton, defamed Clayton online via Reddit, Medium, and her own father's Facebook account, canceled Clayton's paternity test behind his back and accused him of not cooperating, obtained a blood HCG test on the way home from the Ravgen paternity test, falsified HCG blood test results, lied under oath about her providers, was unable to explain who or when she was informed that her fellatio fetuses were fraternal twins, engaged in high-risk behavior without regard for her alleged high-risk fetuses, monster drinks, horse jumping, not seeking OBGYN care, that should be there, failed to obtain any form of mildly appropriate prenatal care, there it is, failed to communicate the end of her pregnancy, lied under oath about the status, progression of pregnancy. My God, this list, it's incredible. Mm-hmm. It's incredible. Falsified photos and videos to appear pregnant, falsified her in-person appearance to seem pregnant, was dishonest and uncooperative with her own attorneys to the point of candor motions. I will say, we believe that those photos and videos are falsified and that we believe that she wore a moon bump. But we never got any subpoenaed Amazon records or anything like that to prove it, which is the thing that I would love to have. I would love that. I do think she has gluten belly. I think that's the explanation. And then also stuck some kind of pillow or something under there. But We can't prove it, which sucks. Was dishonest and uncooperative with her own attorneys to the point of candor motions, defied orders to produce records, failed to cooperate with discovery, falsified documents, failed to attend a properly noticed deposition, sent an ex parte letter to judge making heinous false accusations against opposing counsel, did something hinky with judge duty. Yeah, we still don't know what it is. Falsely accused Clayton of SA, attempted to extort Clayton for $1.4 million if he didn't dismiss the case, failed to provide her own expert witness with complete medical records, sassed the judge while on the witness stand. She did. Has a documented history of PCOS, ovarian cancer and ovary removal, yet claims 3 or 4 or 5 twin pregnancies, one of which was so gosh darn sticky that it survived multiple chemical abortion attempts. So sticky. Multiple surgical abortion attempts and cancer-related ovarectomy. What does HX stand for? HX of MH issues and medications known to cause history of mental health issues and medications known to cause false positives. But somehow, because the judge's father may possibly have quietly sat in the overflow room to see his daughter preside over an unusual yet public case that required, nay, requested, heightened security and bomb-sniffing dogs, the judge is the one who behaved improperly? In the future, if in the future my daughter were in Judge Mata's position, I would absolutely be there to support and protect my child. I would jump on the grenade like Captain America to protect my child and everyone else in that building. You could not hold me back. Internet lawyer Esquire has lied many times, defied the judge's order about not publishing medical info. Yeah, he did that. Slandered and libeled JD's victim, opposing counsel, the judge, and her father, journalists, and everyone with eyes and ears. But yeah, Judge Mata is the problem. For fuck's sake, unreal. That reminds me, if you go visit the merch store, you can get your for fuck's sake merchandise. Where is it? They're super cute. Where is it? Here we go. Oh, for fuck's sake. There's sweatshirts, t-shirts, mugs, all kinds of things in all different colors. I personally like the pink with the orange fox. That's the t-shirt that I have, and I love it. P.S. After internet lawyer Esquire's wall-eyed hissy fit about Judge Mata's Scrivener's error regarding a date, can you blame her given the date confetti that surrounds JD? You'd think he'd be ultra extra careful not to make any of his own dating mistakes, right? But nope, sure as God made green apples, there's a big fat one on page 5 of his manifesto. Looking forward to what's going to happen in 2029, internet lawyer Esquire. You people on Reddit are some of the funniest people on earth. I swear to God, this is so good. This list is eye-watering. Yes, it is. Utterly appalling. This is so good. So good. This is interesting. Pleasantville21 says, here's what I did last night because I have a torn leg tendon. I'm on some great pain meds and a law nerd. Rule 6.1c of the Arizona Rules of Family Law Procedure says an affidavit seeking a change of judge must be filed within 20 days after discovering grounds exist. One thing Internet Lawyer does often in his writing is not specify exact dates, particularly when it's relevant. He'll say around 10 hours before or while I was on vacation. Instead of on June whatever, I wrote to or JD emailed me on June whatever. According to Internet Lawyer's blog post made on June 19th, he emailed the court sometime on June 17th regarding the allegations of Judge Mata sharing info with her father and him attending the hearing, and also emailed the judge whose clerk responded, file a motion. Internet Lawyer then started drafting his notice on June 17th or 18th before Judge Mata issued her ruling on June 18th. His blog post said he could still file a notice if he believed the facts and law supported it. That was June 19th. I remember I pointed that out. I was like, if he believed it? So he doesn't believe it. He doesn't believe that it does support this. For Internet Lawyer to have contacted the court on June 17th, he would have to have knowledge of what he perceived to be an alleged ground to seek a change of judge before that date. On page 15 of his affidavit, he refers to JD contacting him while he was off sailing the seas about social media posts and videos regarding Judge Mata's father. Internet Lawyer doesn't specify on what date JD contacted him, just while I was on vacation. However, the videos were from around the day of the hearing, June 10 and 11, Dave Neal's live stream outside the court being one. He then claims, page 17, paragraphs 74 and 77, that he couldn't ethically make such an accusation formally without checking things first, so emailed the judge on June 17th, again, reiterating this was while he was on vacation. Irrespective of that, if we take June 17th as the day he discovered grounds exist, he had to file his affidavit within 20 days of that date. Under Arizona Rules of Civil Procedure, the day of the act from which a set time period begins to run isn't included, so June 18th is day one. If the time period is 11 days or more, weekends and holidays are included, so that would mean within 20 days ended on Sunday, July 7th, not Monday, July 8th. Sure, little bit of wiggle room, perhaps. However, JD notified him about the disturbing information prior to June 17th. The fact he was floating on a boat. I love you people. Makes no difference. And wandering around the Coliseum with a Bluetooth in his ear and his wife's shorts. He received her communication and therefore discovered grounds exist before then. It's also worth pointing out he blames the slow Wi-Fi connection on the ship for affecting his ability to do things in a timely manner. However, according to his own posts on Twitter, June 12th, he was in the British Airways lounge in London, transiting before a connecting flight to France. June 12th, relaxing in France, letting his followers know being 9 hours ahead of Arizona is great. June 12th through 15th, he's on the French Riviera having a beach day with lunch by the shore watching football in a pub one evening. Do not fuck with Reddit. I'm just saying. Don't. Didn't seem to have any problems posting photos of his hollybobs on those days while he was on land, but claims he couldn't watch the videos JD supposedly sent him of the live streams, etc. Couldn't draft and file a basic notice and supporting affidavit outlining grounds and saying a more fulsome supplementary affidavit would be filed when he's back in Arizona. He told Judge Mata he'd be away until June 28, nearly 10 days before he filed the notice and affidavit. No pesky Wi-Fi on water issues. According to Internet Lawyer, if the date he discovered the grounds exist was prior to before June 17th, to comply with Rule 6.1c, his affidavit should have been filed earlier than July 8th. Not the same day as the deadline for Gregg Woodnick to file the China doll affidavit re the respondent's costs. The rule only refers to the discovery of grounds, not discovery plus investigation plus fact-checking plus researching. Might be wrong, because just a nerd. But not a lawyer, but worth a ponder, perhaps. Oh my God, this is so good. This is so good. Yeah, I thought that was fantastic. All very good points. Oh no, I just had this terrible thought. He was across the pond giving those residents the impression that this is what Americans are like. I am dying of secondhand embarrassment. Oh, Reddit, you're so funny. Look, there's more things he did. Terrorizing journalists with unfounded defamation suits, threats of homelessness, etc. Ruined holidays and momentous milestones for many families, including our own. appropriated the struggles of the DVI-PV community, the prenatal loss community, minority communities, abused resources earmarked for underprivileged communities. Oh, here's more stuff to add to Laura's list of things she did. And who could forget the Chase J. Jones fabrication, the fake bank account, the Chen impersonation, the crying on Facebook vid, the 911 call re Mike Maricini at the trial, tag the friendly neighborhood military medic and hobbyist chef, the anti-Semitic cockroach campaign, the Papa Doe hostage video. We could be here for a week. So funny. Oh my God. Oh, all right. I could be here all day. Let's get to the what the Hale stuff. We got to do that. All right. Before I move on to that, let's read your super chats that came in about this. Wendy A, thanks for the 2, says he's on something wacky. Maybe. I don't think it's out of the realm of possibility. I'll tell you that much. Wendy, thanks for the 5. Get a lien on her house. I used to be a bill collector and used that tool. Grandma Ray, thanks for the 2. Aren't rules supposed to be read as a whole? I guess we'll find out. Unhung Hero, thanks for the 2. Reddit, the great autistic hive mind. It's so true. I'm so proud of all of you Redditors out there. I am so proud of all of you. You crack me up. Oh, that's a good idea. Tweet the list and tag the county attorney. That's a great idea. Everyone should do that. Here, I'll give you the link to the list. Great idea. List of Laura's bad behavior. There you go. Where can you find the merch store? Well, if you're on YouTube, it should be connected to my channel. It should be right below the video. If you do not see it there, you can go into the description of this video or any other video and find a link to the merch store. Or you can look in the comments because the mods will drop the link. Elephant, thank you very much for doing that. But there's all kinds of stuff in there. There's some really fun stuff. Have you seen this one? Hilarious. Sorry for having great tits and correct opinions on everything. You can get that one too. It's good stuff. There's a lot of fun stuff in there. I really need to do some Laura Owens merch. I haven't done any yet. All right, so somebody said I look good today. Thank you. My skin does look good, and I actually just had a bad breakout, but you know what? I've been using castor oil on my face. I know that sounds crazy, but I feel like I look very, I feel like my skin is super soft, and like the breakout is like going away, and maybe it's the castor oil. I don't know. I'm having a castor oil moment. Hello.
Hello again. Work calls.
Fake Laura Owens, thanks for the 5, says, I'm really starting to get the feeling that people might not like me or my attorney.
I don't know what gives you that idea.
Sarah Dawn says, castor oil works. Well, I'm having a moment. I'm having a moment with it. I heard that it can help like that. You know the bumps? You know those little bumps that you get on your arms?
I literally, last night, giving my son a bath, and he has them all up and down the back of his arms.
That's keratosis pilosis or something like that. It's called keratosis something. Pilaris. Is that it?
Yeah.
Keratosis pilaris. Anyway, I have that on the backs of my arms, and I put castor oil on it last night. I can't feel them anymore. You know what? Spawn, you need to put some castor oil on yours.
Yeah.
She is always picking her arms till they're bloody. She has that, and she picks at it, and it drives me crazy.
Is a common autosomal dominant genetic condition of the skin's hair follicles characterized by the appearance of possibly itchy, small, goose flesh-like bumps with varying degrees of reddening or inflammation.
Yeah, I'm just putting castor oil on everything now. just what I'm doing. So this is not medical advice. I'm just, although I've listened to doctors talk about it and they're like, well, it can't hurt anything. So, put it wherever you want it because it's not going to hurt anything to try. But yeah, I have this, what do you call them? Occupational therapist that the kids go to for the anxiety and stuff, and she's really good. But her answer to everything is castor oil packs, and I'm always like, is that your answer to everything? Like literally everything. That's what you want to do is for everything. But I never really tried it. But I decided, okay, I'm going to try it, and so far it's working on my face. I'll tell you that much. My face looks really good, and my wrinkles are starting to kind of fade. I have like this really bad one right here, because I'm always doing this. So I have this particular line right here, and also this. I'm hoping it's going to work on this. I use coconut oil too. I've just started mixing the two because castor oil is really sticky, so it helps to put it with coconut oil.
So this home.
This is good. Capital call out says, I've just been getting tattoos in my worst spots. That's something you could do.
That's some expensive.
Maybe I'll get a neck tattoo. Maybe could I cover up my double chins? Could I get a tattoo that makes me look like I have a snatched jawline? Is that something that they could do?
You just got to get that springy thing to do the neck exercises with.
Springy thing?
Yeah, it was like a.
You mean the thing you do this with?
Yeah.
Yeah. I wonder if that works.
But Cleveland Clinic says apple cider vinegar, baking soda, coconut oil, and water. Drinking enough water may help keep your skin hydrated.
I go through phases of drinking water. I'm like a camel. I will go without drinking water for several days, and then I will drink like a gallon. And I feel like that's fine too. It's fine.
I heard I've been having an earwax problem recently, and I went into
an earwax problem.
Yes,
you need to go to one of those Japanese places where they.
I want to find one of them, but
oh yeah, you
unfortunately,
should go.
I could only go to a CVS, and they said
it's not the same thing, Brad.
I know it's not the same thing, but they took my blood pressure, and they're like, "Do you have a history of high blood pressure?" And I was like, "No, I literally didn't have power this morning, so I probably am not up on my water as I should be." And so now I've got that, and then they did a liter of water in each of my ears to try and flush them out, and it still didn't help. So then they're like, "Just get this over the."
No, you need the Japanese ladies that stick the hot wax in there, and they just
not the
pull
hot
it
wax,
all out
no.
Or whatever they do. They pull some kind of they do some kind of I don't know. They do some sort of pulling that out.
I've seen ones that use the cameraed scalpels that go in there, and they just pull it out.
Yeah, right. With the little twisty things, ear cones that you light on fire. Yeah, they do this weird stuff. You got to watch some YouTube videos on this. There are some insane ear cleaning Japanese things. They also will stick things way down deep in there, like feathers and stuff, and like poke them around.
I've seen the funny fuzzy balls, but I don't know how that works.
Where's my button?
Phrasing?
Don't know how that works.
I've
God.
seen it. That's all I can say.
All right. I have to pull up the news clip. Where did it go? I have my email open here somewhere. No, I guess I don't. Oh. All right, wait. All right, so let's move on to what the Hales, shall we? What the Hales, Brad looking at fuzzy balls. You're never going to live this one down now.
On sticks about this long.
How long was it, Brad?
This long.
Phrasing?
Extra large and extra hard.
Oh, God. All right. I'm looking for, somebody sent me there it is. The link to channel 2. Okay. Here we go. Let's share this. All right. So you guys know, maybe some of you don't know because you've just been following the Laura Owens case here, but before Laura Owens, I was also following another case in the What the Hales saga. Jeremy Hales has a huge YouTube channel. He has like 700,000 followers, and he moved down to, he's like a treasure hunter. He moved down to Florida to buy like a place to winter, and he bought this property, and these other people, these crazy people, moved in across the street from him and tried to, like, I don't know, what would you say? How would you explain this part, Brad? They were trying to grift off of his generosity, shall we say, by opening a turtle rescue that they thought he would like donate to and give them money for.
Well, the idea that they had lived near him in Ohio and followed him as he went to Florida, and then put the stupid turtle rescue donation box thing out in front of their property, thinking that people that were coming to see them would be willing to donate to them, living on this trailer with barely any amenities, and it's just so wild.
It is wild, and this man, John Cook, has pulled a gun on Jeremy Hales before, and there's video of that, and the cops wouldn't do anything. Well, now he's pulled a gun on people visiting Tubetown, which is just a little area for games on Jeremy's property that's across the street from this guy's property. Yeah, I don't think they ever lived in Ohio. They lived somewhere else in Florida.
I thought they... that's why they got the protection order in Ohio.
No. He had to file there because Florida wasn't taking it seriously. He filed in his home state where he's a resident. And you can do that because he's a resident there.
Even though they lived in Florida?
Yes.
That's weird.
Yes, because he didn't want them anywhere near him in Ohio either.
Wow.
All right. So finally, this guy has been arrested because he allegedly pulled a gun on an 8-year-old and her family that was visiting Tubetown across the street. And this is, usual behavior for this guy. This is what John Cook does. And he finally got caught. The cops finally got, I guess, video evidence. We still haven't seen the evidence, but here we go. Let's watch how the news reported it.
Otter Creek from out of state because of a social media influencer. And one person says they were threatened, and another man will now face a judge tomorrow.
They were threatened, Brad. They were threatened. They were threatened. This guy needs to work on his news reporter voice. It's not quite there yet.
A social media influencer. And one person says they were threatened, and another man will now face a judge tomorrow.
I love these little local news reporters. There could be, somebody said this the other day, there could be an entire YouTube channel. I think it was Shizzy or somebody said there could be or should be an entire YouTube channel just featuring these little small town news reporters doing stuff like this.
Media influencer. And one person says they were threatened, and another man will now face a judge tomorrow because of it. TV20's Kayla Lewis breaks down the two sides of the story.
Right behind me is a place called Tubetown here in Otter Creek, based on a...
We have Little House on the Prairie here with the based on Tubetown.
Here in Otter Creek, based on a YouTube channel. Wes Dockery was visiting with his family from Illinois to come and sign this guest book. But he says when he was...
It's the Timu Ben Shapiro.
We've got Ben Shapiro at home.
Who's this? Wish list Laura Owens? I don't know. Or Laura Ingalls? Oh, God. I meant to say Ingalls, and I said Owens instead. Dana Creasy, thanks for the 10, says, Brad, check local waxing spas for ear candle treatment. I'm near the ocean. Sinus stuff, often cheap and painless. Yeah, check salons. Seriously. Specifically the Asian ones, because they know what they're doing. Or, don't you live somewhere where there's a city?
Where there's a city? No, there are no cities here. We only have townships.
Are you serious?
I'm kidding.
Too far? Okay, well then there must be a Chinatown there somewhere. Go there.
Chinatown? I don't think we have Chinatowns. I think our closest Chinatown is actually Chicago.
Well, you would definitely find it there. But yeah, no, look around at salons.
Leaving, the neighbor across the street pulled out a gun.
For my 8-year-old to see that.
Wait, I have to back it up.
The
Watch how
neighbor across-
stiff.
but
Look
he
at
says when he
look
was
at how scripted this is. This cracks me
Dockery
up.
was visiting with his family from Illinois to come and sign this guest book.
She's like, I'm gonna say this, and then I'm gonna reach over and I'm gonna pull this thing out and to sign this guest book. Like by not even looking at it too. That's the
Based on a
funniest thing
YouTube
ever.
Channel. Wes Dockery was visiting with his family from Illinois to come and sign this guest book. But he says when he was leaving, the neighbor across the street pulled out a gun.
For my 8-year-old to see that, and then she just was crying.
60-year-old John Cook is in the Levy County Jail and charged with aggravated assault after he was accused of threatening Dockery and his family last week. Dockery says
She also said threatening. Threatening. What is it with these people and their T's? Threatening, or at least threatening. Like you have to add the N in there. You can't just say threatening. No, I can't even do it now. Threatening. How do they do it?
Threatening.
and his family last week. Dockery says Cook yelled at them.
They're
so
going
he
through
rolled
all
down
the
his
media
window.
journalist interns right now
Charged
because
with
they're
aggravated assault.
They're going through what?
all the media journalist interns because they're out of school at the moment.
After he was accused of threatening Dockery and his family last week.
Threatening.
Dockery says Cook yelled at them, so he rolled down his window.
And I was like, what'd you say? And he goes, do whatever you want. I was like, what? And he goes, do whatever you want. Yelled it again. I'm like, what are you talking about? And he goes, you're going to lose anyway.
But there's two sides of the story. Cook's ex-wife, Michelle Preston, wasn't home when the incident took place, but doesn't believe Cook would do that.
He said that a man had drove by slow filming and that the man had...
Oh, here she is.
Did it get... I didn't know they got a full RV now. I thought it was just a...
That's John's
mobile home.
RV. They've always had that. It's John's. Oh my God, you guys, my rendition of the shed, my Lego build of the shed back here is so good. It's so spot on. I have glued it together. I'm sending it to Jeremy. I just have to get bubble wrap so that it doesn't, shatter.
Destroy
but I have,
itself.
yeah, I have, look at this lady.
He said,
All right, for those of you who don't know her, this is Lynette Preston, who Jeremy calls Lynette Preston. She's the one who's been harassing him. And now he's gotten his Second Amendment rights taken away because they got in front of a bad judge who just will not listen to his side of the evidence. And now it's all in the appellate court because they're trying to get him removed. And so everything is stalled. This man, it took 5-6 months. He still never had an evidentiary hearing for Jeremy Hales. All he did was complain, and you can watch all my coverage of this on the What the Hale said. We've watched the trials, we've watched the hearings. Terrible. MG says apparently the deputy that just came out there pointed out there is no home on the property. Yeah, we know they're living there illegally in a shed on RVs, which you can't do.
Yep.
But they're getting away with all of this stuff. They've been doing it forever. They're not up to code. There is no house. They're living in a shed, a literal shed. You saw the shed. Here, it's right behind her. They're living in a shed. This is a garden shed. You know that you go to the Home Depot and you buy, and they come and they deliver it to your house. There's no electrical. They're pooping in a bucket and throwing the slop on right there, like feet from this trailer. We saw it last night. It's so illegal how these people are living. And there's a child there who's just like 5 years old. No plumbing, no air conditioning in Florida. Oh my God, it's terrible.
We were just there.
Yeah, and it's so hot there. Oh my God. It's so hot.
a man had drove by slow filming and that the man had shouted something to him and he had been behind.
She just said, I wasn't there. So how are you interviewing her for her?
A man had drove
She
by
was.
slow
Let's hear
filming.
that. I wasn't there again.
But there's two sides of the story. Cook's ex-wife, Michelle Preston, wasn't home when the incident took place.
Wasn't home, but we're going to ask her what happened anyway.
But doesn't believe Cook would do that.
He said that a man had drove by slow filming and that the man had shouted something to him and he had been behind the magnolia tree.
Dockery says after Cook yelled at him, that's when Cook pointed his gun at their car.
And I'm thinking, if I pull off, is he going to start shooting or what? So I want to try to talk him down.
Preston says Cook was at home, and if he did pull out his gun...
Oh, God, that's the blessing box. So according to the dad, the little girl got curious and went over and wanted to look in the blessing box to see what was in there. And then he called her back. He was like, no, we're over here at Tubetown.
Mm-hmm.
And, but that's like luring people onto your property to then threaten them with a gun.
Right.
It's just ridiculous. That should be a separate charge.
And he had every right to do so.
Instantly threw it in reverse, and when he did, his hand came out the window with something held out the window. John doesn't see very well. He couldn't tell the difference between a gun or a phone.
Well, then he should definitely not have a gun.
Well, he said that a person was driving down the street recording them, and then he saw them hold something out their window. If he knew they were recording,
then he knew it was a phone.
Yeah.
This is their sign for real? Oh, no. This is the most Florida thing I've ever seen in my whole life.
You are not a nice person.
This is so crazy.
Levy County Sheriff's deputies say lack of evidence and conflicting statements hampered the investigation before a warrant was served. After that, evidence of the supposed assault was recovered as well as the gun. In Otter Creek.
Why does she say supposed assault when they recovered the evidence and arrested the guy? Clearly they found evidence of an assault.
Kayla Lewis, TV 20 News.
Oh, Delilah. I mean...
bye-bye.
It's a cute dog. It's a very cute dog. I'm just glad they finally got the guy. Okay, now I'm hearing... It should change their name to It's a Jail Thing. I'm hearing that there's a $75,000 bond. Is that correct? There was a bond hearing this morning. I wonder if anybody got that. Let's see. So Tubetown is live right now. So there's probably some updated info there, but he had his bond hearing this morning. And I heard last night on MG Law that they didn't usually do Zoom. I think people were trying to get access to Zoom, but they don't usually do it for the bond hearings.
Mm-hmm.
Yeah, I'm not seeing it, so it doesn't look like anybody got it. What's Jeremy up to? Let's see. God, it's about time they finally arrested this guy, though. Like, seriously, I'm so sick. I'm just so sick of his harassment of innocent people. Yeah, I don't see any updates. Let's see if he has any shorts updates. But I did hear that the bond was set at $75,000, so he will probably not be getting out.
No, because 5% of that is $3,750.
Yeah, he won't be. Well, I mean, he does have a really expensive truck, though. I mean, and that RV is not cheap either.
Hey, I was right.
So, MG says it should have been higher. Yeah.
Dawn says they see 750,000.
Well, I guess we don't know until we get it, reported somewhere. MG says he couldn't find anything this morning. I heard that it was being reported on Tubetown that it was 75,000, which sounds about right to me. I don't think it would be more than that. Dawn says she saw in Levy County his bond is $750. Maybe it's on the Levy County Sheriff's page.
Yeah, I'm looking at
let's
something
go
right
look at
now.
that. Let's look at that. All right, here's the Levy County Sheriff's page.
John Cook found 75,000 bound.
Where did you find it?
On this Public Safety Cloud website.
What? What's a public safety cloud website?
I don't know. Jail Tracker, publicsafetycloud.com. That's what it's called.
How did you find that?
Anyway, bottom out, 75,000. Surety cash.
Cool. Okay.
Says pending, so I don't know.
Does that mean he hasn't paid it?
I imagine. But this came from...
It's a hell of a mugshot, John. Good work. Well, I hope that the people who stood up for these two and went after Jeremy feel stupid for doing that.
Yeah, so...
Because Jeremy wasn't even involved in this. He wasn't even in the state. So you can't call him an instigator when John Cook is out there terrorizing, just visitors to Florida. He's out there harming tourism in Florida.
Mm-hmm.
What is this? Oh, I have...
So, bailbondsnow.org, and they had Levy County inmate search, find an inmate, and then that's what brought me here.
Ah. Of course she is, Rose Lady. Of course she's defending him. Because, she doesn't have a choice now. She's picked her side, and she's not going to admit that she was wrong. Charges are... Oh, MG says the charges are still pending, not the bond.
Yeah.
Do you think that they're... MG, do you think that means that they're deciding what they're going to charge him with? Possibly adding things?
Yeah. So the offense would be pending, but the cash surety would be the 75,000.
Mm-hmm. Wait, does that mean the cash he has to come up with is a full 75 or 10%?
I think
I'm confused.
He'll probably have to do the 10% if he wants a bondsman to pay it, but he probably would have to pay the full amount in order.
Okay. Jeremy provoked it by allowing Travis to build Tubetown, is what they're saying. Are you kidding me? What's provoking about that? For people to come and play games? Well, why is that provoking? I don't understand. They moved across the street from a YouTuber on purpose. They knew that Jeremy was building Tubetown. He wanted to build a place for Airbnbs on his property for fans to come and stay. They knew that. This was his plan going in from the beginning. And she was a fan of his. So she knew that. So you cannot then complain when you move across the street from a YouTuber that you knew was planning to bring tourism to his property. You cannot then complain and say him doing that thing that he said he was going to do is somehow instigating you to behave badly and point guns at those people that he was bringing there, that he told you he was going to bring there. That's the dumbest argument ever. Allowing Travis to build Tubetown. Well, they had plans to build Airbnbs too, but who the hell would want to go stay there now with these crazy people across the street? And I thought it was really cute too. Mm-hmm. It's bringing too much traffic. Again, she chose to move across the street from a well-known YouTuber who was trying to bring more tourism to this little area of Otter Creek. She did that. She moved there. I live in a vacation town. You don't see me complaining. I moved into a vacation town that I knew in the summertime was going to be packed full of people from New York City that I freaking hate, that are going to be crowding my streets, crowding my grocery stores, crowding my beaches, and blocking traffic. But I live here. I moved here purposefully. So I can't complain about it now. I just avoid them. That's why locals have their local spots, to avoid the tourists, whatever. She's the one that did it. She moved there to be next to him. She can leave anytime she wants to.
Easily. They just drive the trailer away.
Just drive away. Yeah. Oh my gosh. Yeah, she also put out her address. She wants people to go there and use her blessing box. Like, this woman is ridiculous.
So what's the status on the request for judge recusal?
That's going to be forever.
Oh.
We said from the beginning it was going to be like 15 months. Fake Laura Owens, thanks for the 5 fuzzy balls. That's my nickname for my favorite attorney. Kirby Johnson, thanks for the 5. Lynette called the Ohio mayor and threatened Jeremy Hales and warned the mayor about him. That's right. She did. Wizzy Wheels, thanks for the 2. At least Crook will have a real toilet now. I actually think he's the only one that had a real toilet inside the RV. Fake Laura Owens, thanks to the 5. I tried looking in my blessing box. I could never get the mirror at the right angle. Fake Laura Owens, thanks to the 5, says, hold on now. $1,000 in Levy County is like $1 million bail in the rest of the world. It's true. It's true. Poor Levy County. They really need to get fixed
a handle
up
on their stuff.
They need to get a handle on their shit. I'm trying, MG, to get your... Oh, I see. You sent me the same screenshot Brad showed me. Okay, thank you for sending me that, MG. I appreciate that. Brad got to it. Oh, this is interesting. David Gingras has responded to why he has closed down his tweets. He said, I've stopped allowing comments because the bullshit isn't helpful. Well, except for the sleuth who posted the crap that Mata copied. That was very helpful. What? If you want to comment, that's fine. If comments are rude, abusive, I'll just turn them off again. Thanks. Oh my God. He's really something. God, this guy. All right, so what else is going on? Okay, so in the Karen Reed thing, in the Karen Reed debacle, see, let's get over to Larry's Twitter. Because I'm wondering if anybody came up with, did anybody come up with the affidavit of the fourth juror?
Because I can't posted it yet. I think I saw that a fourth juror was about to come out, but I didn't actually see any documentation from that.
No, they filed another motion that said one did come forward and they have the affidavit, but we didn't see the affidavit. But a fourth juror has come forward to Karen Reed's defense team and said, yeah, we all were unanimous that it wasn't murder. Now here's the new motion by the opposition to the defendant's post-trial motion by the prosecution. Look at this. Meanwhile, in the Karen Reed case, says Larry, the prosecution is alleging that defense consented to a mistrial, so now they have no right to object as they had an opportunity to do so in court and failed to do so. That Alan and David remained silent, and that removes any double jeopardy bars to a retrial. Oh my God. Contrary to representations made in the defendant's motion and supporting affidavits, the defendant advocated for and consented to a mistrial as she had adequate opportunities to object and instead remained silent, which removes any double jeopardy bar to retrial. See Commonwealth v. Fetsia. Consent to a mistrial may be inferred from silence, where a defendant had the opportunity to object and failed to do so. Wow, I hope that is not the case.
Because I watched them do the verdict, or they called the misverdict, and she read the note, and then they said, okay, we're going to bring the jury in. The jury came in. She goes, I'm declaring a mistrial, and then sent them on their way. I'll be there in a second. And then that was it. Like, it was done pretty quick. There was not much time for somebody to object to not getting a poll from the jury.
Yeah, I'd like to see this entire thing. I wonder if somebody's posted it on here. This is such a mess. What a mess. What a total mess. I need to write about it. But it's a total mess. It's a total mess. That was, yeah, here it is. Lacks any merit. Karen Reed, prosecution files opposition to her motion to dismiss. But did they link the document? No, of course not. They never do. I wonder if I could find it somewhere online. I
am not a robot. Click all of the pictures of cars.
What? A plea deal already? Nuh-uh.
Wow.
Is that happening right now? In the let's get over there. Is that happening right now in court? A plea deal? Holy shit. We're not going to get to see Alec
on the stand?
On the stand? Oh, here we go. Share screen. The hell is happening here?
Hancock. At that point, we've heard about Seth Kenney's involvement in this, his effort to pry into what's going on with the prop card and the bullets. And so on that phone call, he's telling Corporal Hancock, then Detective Hancock, that he believes he knows where the live bullet came from. He dials in a guy named Teskey, who we heard about yesterday in testimony. Teskey gets on the line and Seth says, tell Detective Hancock what you know. And he says, well, Fel Reed dropped off a batch of live ammunition at my business because I have a safer place to store it. And after that, Fel shows up, grabs some of the live ammunition and leaves some behind. And that's what I know. And Seth says, well, that could be from the same batch that killed Helena Hutchins. Could be a match. He says, and it's Del Reed and it's Hannah Gutierrez Reed. That's the one who's responsible here, pushing it off on Gutierrez Reed as the source of the live ammunition, just as the state has done in this case. He says, thank you very much. He gets off the phone. Fel says, I am, Teskey says, I'll take a picture. I'm not in front of my computer, not in front of my ammunition. I'll send it in an hour. He sends a picture of 4 bullets. Ms. Morrissey is going to hold that up to you and say, these are the 4 bullets you knew about this. That was from 2021. Detective Hancock does not preserve the other live ammunition that's at Teskey's property, even though he told her this could be from the live ammunition batch that matches the bullet that killed Helena Hutchins. 2 years later, November 2nd, 2023, there's a PTI of Teskey. Ms. Morrissey's asking questions, and she starts probing further into the live ammunition that Teskey had previously said was given to him by Fel Reed. And she says, do you still have some of that ammunition? He says, well, some of it, but I've been out shooting it over the last 2 years because Detective Hancock did not preserve it over that time period. Ms. Morrissey probes further. Where'd it come from? Tell me your story. He says, well, Fel dropped it off. He then picked some up, and he went with Seth Kenney to the 1883 Yellowstone movie, where he was teaching people how to shoot with that live ammunition. He then went to another movie with Seth Kenney, teaching people how to shoot with that live ammunition. And Seth Kenney then took a green ammo can with that live ammunition in it and brought it home with him. He says that could be the live ammunition from that green ammo can that killed Helena Hutchins. Ms. Morrissey says, I want you to preserve that. And do you think there's any evidence that this was sabotage? And he says, well, actually, Seth Kenney called me while Rust was shooting, telling me he wanted to get Hannah Gutierrez-Reed fired. But he didn't know how to do it because he was concerned about upsetting Fel Reed, significant armor in the business, as Your Honor knows. And so he says, I don't have evidence that there was sabotage, but that's what I know, and I still have this ammunition.
They're really going for this bullet theory.
Know,
they have been trying to convince everybody that there's this giant conspiracy to hide the ammunition and throw, and maybe they did do a bunch of that stuff, but I don't know how that relates to whether or not Alec Baldwin is guilty of pointing a gun at somebody and pulling the trigger when he didn't check it. Larry tweeted out, the prosecution's table is empty. This was 20 minutes ago. Are they typing up paperwork for the defendant to sign? All the defense attorneys are smiling and looking happy. Alec is telling jokes. One of the court people tells me she heard the words conditional discharge. That could mean that Alec may be taking a plea and he will serve no jail time, and there will be some time on the shelf hanging over his head. Example, if he does not get in trouble for X number of months, years in New Mexico, then all charges will be dismissed. This is standard in the defense world. What a day, folks. But then it looks like the defense team has come back in here to try and argue some kind of Brady violation, probably in front of the judge. Are they trying to get a dismissal? I don't know. I don't know what this is about, but I don't think the jury's in the room because the lawyers can't testify. So whatever this is just in front of the judge. Brad, you're muted.
He's just telling a story and going on and on. I was like, wait a second. He's not questioning someone. There's just a whole lot of...
No, he's in front of just the judge. The jury couldn't be here for this, but whatever he's doing, he's building his conspiracy.
Zachary, the one who threw the live bullets away, we don't know, live or not, threw bullets away after the incident on Rust, admitted that. Was on set, texting with Seth Kenney, angry with Hannah, on the license, the ATF report for the Pieta that was involved in this accident. She was on set. They were close, we know that. And so Ms. Morrissey says, you hold on to that evidence and I'll come get it, in essence. She never does. November 2023. Fast forward to March 6, 2024.
Oh, they're replaying something. They're on a break.
Mm-hmm.
Yeah, what are they replaying?
Issues with these, with the counsel on both sides that we don't know. For some reason, they don't want the court to hear that. They don't want this to be broadcast publicly.
Neither side it appears.
Right. No, and so, but at the end of the day, we don't know.
Yeah, we really don't know. It's all speculation. But it seemed like Hilaria Baldwin and me trying to read the body language. She was kind of giving him a reassuring pat at one time, like like a go get him kind of type pat on the back from what I could see. So we're all kind of just trying to read the tea leaves here, the body language. How big of a deal is what happened this morning? How big of a deal is this with the 4 rounds that were turned in by Troy Teskey after Hannah Gutierrez-Reed's conviction? There's a report written put under a different case number, not turned over to the prosecution.
He turned over rounds after her conviction. Is that real?
Mm.
Oh my God!
Turned over to the defense. How big of a deal is this? Because you look at those rounds, and they do look distinctly different from the ammunition that was supposedly the ammunition that killed Helena Hutchins.
Right. Well, again, this has been a theme throughout this, the fighting between the defense and the prosecution over discovery. The defense has made so many allegations about discovery violations and they have to do that. That's their job, and they have a good faith basis for doing that. In this particular case, they want the jury to have as much information about Seth Kenney as they can. They want to point the finger.
Right.
They want to establish that Alec Baldwin is so far removed from what actually was taking place when he's just simply the guy holding the gun, filming the scene, and all these other things were taking place at a different level. They want the jury to have so much doubt. They're just trying to build.
All right.
Knew about this somehow because they brought it up on cross-examination yesterday, but they.
All right, so basically, court's on a break, and during the break, Larry says Alec is having an extensive conversation with his family. I cannot hear what he is saying. Interesting. Interesting. So there might be breaking news in this case soon. Larry also said everyone is hugging and the atmosphere seems very lighthearted in court. Alec making jokes. One of the court personnel laughs out loud. He seems very happy. Yeah, I mean, I know he's the one that pulled the trigger, and I know that wasn't in the directions and everything, but I do think there is we didn't get to the testimony yet, though, about his defense attorney says that SAG rules don't have anything in it about actors having to recheck the weapons. Now, I realize that anybody who's ever worked with a gun, in gun safety, that's what you do. Everybody checks the gun. The question for me is that the standard in the movies? If it isn't, then I don't see how you hold him. He's been doing this for 40 years. He claims that he's never been instructed to do that. That when a props master and the arms guy on the set hands him a cold gun saying cold gun, you believe them. Now I know that everyone who's ever worked with had a gun, or they're all like, that's so stupid. Yeah, I understand. But we're also talking about a Hollywood movie set versus what you do in your real life and how you're trained. They're obviously trained in a different way. It's possible. Now, that doesn't mean, courtroom's back live. All right, hold on. That doesn't mean that they shouldn't have those standards. No, it says they're still on a break. There's very few actors that
Larry tweeted 3 minutes ago that says lawyers are back in court, no judge yet.
Wait, come here. What do you say? I can't. Don't talk off microphone.
Okay. There are very few actors that actually know about guns, and those few actors are Keanu Reeves, Will Smith. I just said it, and there's definitely a few more. I just don't know of them, but they take courses, they go to gun ranges, and they know about guns. Other actors barely know anything about guns other than you pull the trigger and they fire. So they hire on movie sets gun experts to do that for the actors because they don't know what they're doing. And they show them how to use a gun, how to reload it, how to put the safety on. So they don't expect actors to know. Only a few of them actually pay attention.
But they make the question is it in the rules for them to recheck the gun once they have handed it to him? Now, MG says the rules do cover it. Adam Baldwin was on with Andrew Branca and showed the SAG rules. So you're saying it's in the SAG rules. Wait, we need to get those. Why are you guys saying court's back in session and I'm literally here on Law and Crime and it's just court is on break?
WDBJ7, your hometown station, says Alec Baldwin trial on hold as judge considers defense request to dismiss case over questions about disputed ammunition.
Trial stream. I'm here to tell you about our sponsor, Truthfinder.
I don't want to hear this.
Shut up. It says defense request to dismiss the case over questions about disputed ammunition. So if there was a Brady violation after the other cases, and they not present exculpatory evidence or evidence in the case, and they're now going to trial, then they could get a mistrial.
How hard is it to find this Screen Actors Guild safety protocols on movie sets? Let's see. Here's an article. But I really just want to see the rules. Weapons master is required to be on set whenever a weapon is being used. The Actors Equity Association's guidelines state that before each use, make sure the gun has been test fired off stage and then ask to test fire it yourself. Like as an actor, watch the prop master check the cylinders and barrel to be sure no foreign object or dummy bullet has become lodged inside. Further, all loading of firearms must be done by the property master, armor, or experienced persons working under their direct supervision. Nowadays, all weapons are checked before your blanks are put into the weapon. The blanks themselves are never loaded until the very last minute when all crew is in position, so the armorer knows exactly where every member of the crew is so that no one's walking through any danger areas the armorer has set up. Okay, well, that still doesn't answer the question.
Yeah. I sent you a clean feed of the camera.
Oh, okay. Great. Ooh, what channel is this?
AP.
Oh, the AP. Nice. Well, I wonder how long this is going to go on. This could go on for a while. So this is based on, so they want the judge to dismiss it based on this evidence that the bullets were messed with.
Squid sent me the safety bulletin from SAG, so
Oh, good.
let me get that loaded up.
They always have me check before. Well, okay. So MG says he was definitely not supposed to point the gun directly at someone and pull the trigger. But wait a minute. He was under direction to pull the gun out of his coat, and I heard somebody say, "Whip it out," and they said, "Do it again, just like that." So he was doing what they asked him to do. So wherever he was pointing it was where he was directed to point it. He says she leaned over the camera and was in the way of the gun. Like, he wasn't pointing it at her. He was pointing it where he was supposed to be pointing it, and she moved into it. Now, I don't know why he ended up pulling the trigger. And, have you ever pulled the trigger of a .45, by the way?
Yes.
It's really hard to do.
Well, not a revolver, I should say.
Not a revolver. Well, revolvers, triggers are so hard to pull.
Because you're activating the action to rotate the cylinder in addition to... So it's...
Yeah, they are so hard to pull. I need like 2 hands to do it.
Phrasing?
That's what she said.
I know they didn't ask him to pull the trigger, but I am confused as to how that happened. I mean, maybe men's hands are just that much stronger than mine, but like, I would have to really pull it hard.
I'd find it hard to believe that there isn't an updated version of this, but this is 2009 is still relatively recent.
Somebody says John Cook got out of jail. There is such thing as a hair trigger, but on a revolver? I don't think that's possible. A revolver is a mechanical gun. You have to pull, when you're pulling the trigger, it rotates the barrel, right? And it also, the hammer has to be back. And it has to slam the hammer down. I mean, it's a whole mechanical operation with a revolver. And I've pulled the trigger of a revolver before. It is difficult. It is not, and maybe that was his gun was different. I don't know. No, I didn't see the testimony of the gun maker yesterday. What was there something interesting there? Oh, I agree with you that it seemed that all of it was reckless. The way that but to me, it's the person they hired as the armorer. She had no experience. She had, I guess, everything in her was completely disorganized. She had live rounds and dummy rounds in the same box. They were asking for an accident. I just don't know if that's the actor's fault. I still have a question there.
Once you take the producer aspect out of it, and I think some of the most interesting evidence was that video they showed during opening yesterday, or 2 days ago, where he's walking him through what they want him to do.
Mm-hmm.
And he's not being overbearing. He's not saying, I'm going to do it this way, I'm going to do this. He's taking direction, trying to act.
Direction, yeah. He was. I mean, nobody thinks that this wasn't an accident.
Mm-hmm.
But I kind of feel bad for him. I really do. If he's saying that throughout his 40-year career, he has never checked a gun, like he's never been required to do that. Nobody ever told him to do it. He's always trusted his armorer on set. And they say cold gun, and that's what you do. It wasn't like he was waving it around and playing, right? He was doing the direction. I don't know. I feel bad for him. I do. I feel like he must feel terrible about this. And I don't like Alec Baldwin, you guys. I don't like him, but I just am not sure he should be guilty of this. I think that armorer, the one who is in jail for it, is the correct person to put in jail for this.
And I think that the intentionality of wanting to kill, that's the intentionality is part of the charge. So he has to have the mens rea of wanting to kill her, and I just don't think you're going to be able to get there.
Well, I guess the argument is, if you are pointing a gun at someone, the intention, because that's a possibility that you could kill them. Your intention is there.
Or negligence, yeah.
For negligence, yeah. But MG says, I'm comfortable with deferring to the analysis of Andrew Branca when it comes to this issue. What did he say? What did Branca say? MG says, intent is not an element. It would make it first degree.
Oh, that's right. I'm sorry. I for some reason I kept hearing intent during opening. That made me believe that it was a part of the charge.
They did a lot of weird things during the opening, though. They kept using the word homicide instead of manslaughter, which I thought was strange. Yeah, I mean, everybody wants Alec to be guilty of this because I personally think it's because they just hate him. I don't really like him that much either, but I just don't want some guy to go to jail because people hate him. MG says, on its face, Alec is guilty of the charge. That's what Branca says.
Interesting. He would be the one to know. So Squid
okay,
gave
here we
us
go.
these, and it says firearms and other weapons. Treat all weapons as though they are loaded and or ready to use. Do not play with weapons and never point one at anyone, including yourself. Follow the directions of the prop master and or the weapons handler regarding all weapons.
Yeah, see, now I would think that he was not playing with it. He was following the directions he was given. He says he didn't point it at anybody. If she moved in front of the gun while he was doing the direction he was given, is that pointing it at someone? I don't know. What else does it say? Anyone
handling a weapon shall receive the proper training and know all operating features and safety devices. If the firearms and other weapons are used in filming, the prop master and or the weapons handler must meet with cast and crew and inform them of the safety precautions in effect and answer any questions. Additional information can be found in Safety Bulletins 1, 2, 16, and 30. I think that's it.
Yeah, I don't think that that's very clear. It does not say that every actor shall inspect the gun themselves to make sure that it isn't loaded before handling. It just says follow the instructions of your armorer.
Here's Safety Bullet 1. Blanks can kill.
And yeah, live ammunition is never to be brought onto any studio set. MG says that the people were saying he was apparently mishandling frequently on the set. Well, where's that evidence? Have we seen that evidence? Doesn't it only matter if he was mishandling it in the moment? You're saying he blew off the safety training sessions? Well, he shouldn't have done that. Yeah, I don't know. I'm conflicted. I really feel like the people responsible for this are the people who brought live ammunition onto the set, the armorer whose responsibility it was for this not to happen, and whoever else, the other guy whoever that assistant director was who handed him the gun, that those people should be in jail.
Before the use of any firearm in a rehearsal, so that's good to know. So it went that training or that montage that they showed during the opening, that would have been a rehearsal and an on-camera sequence, so that would be rehearsing all on camera. Or off-camera use, all persons involved must be briefed at safety meeting, on-site walkthrough, dry run. No one shall be issued a firearm until he or she is trained. Well, if he goes
If he
around
wasn't
saying,
properly trained, of course, he's saying he's been, using weapons for 40 years. He had to have been trained at some point.
But is it each filming? Do you have to get
I don't
training?
know. That's a good question.
Because honestly, I would say that would be a good thing to say, is that each unique filming requires going through the training, and your past involvement in any works does not constitute having been trained for this filming.
I think that's a good rule, and it probably should be the rule. I don't know if it is. But if it's not, it is not specifically stated, though, in those SAG rules. And I understand that SAG rules don't supersede the law, but if they're not training the actors on the law, how are they supposed to know? But if you're training them on gun safety, you're supposed to be training them in the law. Yeah? You would think that those training sessions are supposed to be the legal requirements of handling a weapon. So then they all should have been trained that they always have to check the gun. But I even wonder, if he had checked the gun, would he have even noticed the live round? Did you see those rounds right next to each other? The ones that were not. Oh my God, they look the same. To me, to the untrained eye, I'm looking at it going, how the hell would I know the difference between the one that's live and the one that's not?
Do we have those photos? I'd be interested in seeing those.
I saw him in court. They showed him in the. Was it court that I saw that, or an article? But I saw them. Maybe I was watching Law and Crime. They were showing bullets next to each other. No, it was when one of the witnesses was on the stand. They were asking her, which one of these bullets, like these two on the left, are these live or are they dummies? And she was like, oh, these are dummies. And then what about these over here? Well, this one is live. It's like they looked the same.
So this one has a silver cap instead of a brass cap. And then, yeah, those look nearly identical.
They look nearly identical. So is an actor who is not an armorer, not the gun expert, if you open you open the gun and you look, are you going to know the difference? All right, MG says the dummy rounds rattle. Are you supposed to take them out and shake them? Like, how many of these checks are supposed to happen? Like, frankly, I'm upset by the fact that you're supposed to have these experts on the scene and they could make this big of a mistake.
So for those who are uninformed, the AR-15, we frequently use blanks in my training down in 2007. And you get these really funky shaped bullets because it's literally this brass cap here that's just like crimpled around. So it's just gunpowder in a thing, and then it opens up a little bit and makes the noise and everything, but it doesn't. There's no bullet to actually go. It's this pointed end here is the actual bullet that's going somewhere. So it's real easy to determine what's a blank and what's not because there's no bullet there to go anywhere. So it's really interesting that this
but blanks and dummy rounds are different, aren't they? So there's a couple of different. They were talking about this. blanks, they showed the crimped ends, and I could see the difference between those and the live rounds very easily. But there are dummies, and they look real. So I don't. This is the point right here. Satori Hike says live rounds shouldn't have been on the set. Period. Whose fault was it that live rounds were on a movie set? Was it Alec Baldwin's fault? Hannah is the one who is the main source of fault in this. And I realize everybody wants Alec Baldwin to be guilty, but I want to look at him like just some other actor, some unknown actor that we've never heard of. Would we feel the same way if it was just some other guy? And I just, it feels wrong. To me, it feels wrong. It feels like he was failed on so many levels by the people who were in charge of checking this stuff. So regardless of his, I guess his behavior on set, if he was encouraging this kind of, negligence or playing around with weapons, if he was encouraging that, maybe that makes a difference. I don't know.
Oh, here's an interesting thing.
I just feel weird about it. I really do. And I don't like Alec Baldwin at all, but I feel weird about it because I put myself in his position. And if somebody hands me a gun, and I don't know much about guns, but this expert who tells me that this is a safe gun, like my husband, for instance, I believe my husband, if we go to the shooting range and he hands me a safe gun, tells me the gun is safe. I've never checked it. I've never done that. Now it's because I know that he just did. I guess it's not like something we do all the time, and I don't really like shooting, so I have no interest in it. Every time I go, I always hurt myself, so I don't like shooting at all.
I think there's a difference though if you're at a shooting range and if he's loading it and getting it ready for you and then hands it to you to shoot, that's a little different than someone handing you a gun away from a firing line and whatnot, because the expectation's different.
Well, this is another question. Doesn't he have a duty as a producer to hire a competent prop master? I don't know. Is he the one that did the hiring? I don't know. Did we get that yet?
His role as a prop master has been removed from the court case, so it is only
his
Alec
role
Baldwin.
as a producer, you mean? Right. Yeah. So that's clearly not an issue in this case. It wasn't the armorer that handed him the gun, but wasn't it the next guy in charge, the second
assistant director?
It went through the armorer, then the assistant director. So two people. It went through two people who had a duty to check that weapon. And it's just I feel like that's really unfair. Who's David Hales?
I don't know.
And the armorer was found guilty and the AD pled guilty. Oh, David Hales must be the assistant director. Well, yeah, they were guilty. But then does that mean that Alec was guilty too? I don't know. I just don't know. I guess I trust the jury. I trust the jury on this one. All right, I'm going to get going. I got to get other things done today. I hear that Larry, DUI guy, is streaming. So if you guys, maybe we'll go redirect you over there because he was in the courtroom and he can tell you what was going on. So let me get over to the studio and redirect you guys. Where is my studio? What, did I shut down the studio? No, here it is. All right, let me redirect you over to Larry, and you guys go tell him that I said hello, and you can get all the updates and with way more information on this case over there because I am not following it as closely as he is. But I will see you guys. This is your last chance, by the way, to send breadstick money. I am still paying off those droids. We've paid off all the bags and about half of a droid. We've got 2.5 more droids to go, and I would appreciate that. I appreciate that very much. Let's see. Let me make sure I didn't miss any Venmos. Oh, I missed a text from Reality Steve, though. All right. All right. Let me see if I don't think I missed any. I will see you guys later. Thank you so much for being here. And go tell Larry that I said hello. See ya.
Yeah. Give me breadstick money, yeah. Yeah. Give me that breadstick money, honey. Breadstick money, yeah. Yeah. Unlimited supply coming at you on the fly. With that goopy super cash making them cry. We're taking all our honeys to Olive Garden, spreading breadstick money like fire in the oven. Give me that never-ending salad amount of strong ink. Can't get enough since it's raining only money. $1.99 times 100 fast stacks. Hanging on the mic, spitting mad facts, making jokers mad cause they never gotta laugh. Cracking people's sides, making liars take a bath. On the mic daily and nightly, holding it tightly, poking the mighty plane in our T-Go teeth. Yeah. Give me breadstick money, yeah. Yeah. Give me that breadstick money, honey. Breadstick money, yeah. Yeah. Unlimited supply coming at you on the fly. With that goopy super cash making them cry. We're taking all our honeys to Olive Garden, spreading breadstick money like fire in the oven. Give me that never-ending salad amount of strong ink. Can't get enough since it's raining only money. $1.99 times 100 fast stacks. Hanging on the mic, spitting mad facts, making jokers mad cause they never gotta laugh. Cracking people's sides, making liars take a bath. On the mic daily and nightly, holding it tightly, poking the mighty plane in our T-Go teeth. Register ringing, pocket singing, subscribers opinion, we just see it screaming. Give me breadstick money, yeah. That goofy cash, honey, yeah. Give me breadstick money, yeah. That goofy cash, honey, yeah. We're the Pawn Skunk Posse, swimming around, diving deep for the truth that's buried underground. Short, skinny jeans, latte in the blender. Swiping through the news, it's so fake, call it pretender. Reddit bros blowing journals out the water. Breaking big news like some Upper East Enders. No rolls, no pins, no Lambo budget. £2 does it for the breadstick money, yeah. Give me that goofy cash, honey, yeah. Breadstick money, yeah. Give me that goofy cash, honey, yeah. Breadstick money, yeah. Yeah. Give me breadstick money, yeah. That goofy cash, honey, yeah. Give me breadstick money, yeah. That goofy cash, honey, yeah. We're the Pawn Skunk Posse, swimming around, diving deep for the truth that's buried underground. Short, skinny jeans, latte in the blender. Swiping through the news, it's so fake, call it pretender. Reddit bros blowing journals out the water. Breaking big news like some Upper East Enders. No rolls, no pins, no Lambo budget. £2 does it for the breadstick money, yeah. Give me that goofy cash, honey, yeah. Breadstick money, yeah. Give me that goofy cash, honey, yeah. Breadstick money, yeah. Yeah. Give me breadstick money, yeah. That goofy cash, honey, yeah.